International maritime law, applications of competition rules to the maritime sector, the introductions to competitions law, Article 101, TFEU, which with regards to prohibitions of collusions, horizontal agreements, applications to the maritime sector, exemptions under Article 101, Clause 3, horizontal agreements in the maritime transport sector, vertical agreements in the maritime transport sector, historical context, Regulations 4056/86, repeal process, impact of the repeal, the current framework with regards to the guidelines and market definitions, horizontal agreements in maritime transport sector. Competition law is an evolving field with significant implications for law, politics, and economics. Its primary goal is to safeguard the competitive process, ensuring efficient resource allocations in markets and maximizing consumer welfare. Without regulations, businesses might collude to fix prices, abuse market dominance, or create mergers that concentrate economic power, hindering competitions. The EU competitions law is unique, developed from legal traditions of its member states. It governs four main areas under the Treaty on the Functioning of the European Union, TFEU, collusions and anti-competitive agreements, Article 101, abuse of dominant market positions, Article 102, state aid control, Article 107, merger control, Council Regulations 139/2004, European Council. Article 101 TFEU prohibits agreements, decisions, and considered practices that may affect trade between member states and restrict competitions. Its structure includes, such as under paragraph 1, general prohibitions of collusive behavior covering both horizontal, such as agreements between competitors, and vertical, which is agreements between suppliers and retailers agreements. Paragraph number 2 declares prohibited arrangements void. Paragraph 3 provides exemptions for arrangements creating efficiencies, provided they benefit consumers, are indispensable, and do not eliminate competitions entirely. The key developments in maritime sector, Regulations 4056/86. These regulations provided a block exemptions for liner shipping conferences, allowing collective rate setting and capacity sharing agreements. The rationale was that such conferences were necessary to enhance productivity, capacity utilizations, and service quality, and to grant stability to the maritime sector. However, this regulations was repealed in 2006 by Regulation 1419/2006, fully subjecting the maritime sector to Article 101. With regards to horizontal agreements, it includes price fixing, market sharing, and quotas, pose the greatest threat to competitions. These agreements are considered hardcore restrictions and are typically not eligible for exemptions under Article 101, Clause 3. Information exchange agreements are also contentious due to the potentials to facilitate collusions by enabling competitors to monitor each other's behavior. Price fixing, it is agreement between competitors to fix prices. It is strictly prohibited as they eliminate price competitions, leading to higher prices for consumers. Market sharing agreements to divide markets among competitors, such as geographic area or customer type. reduce competitions, and are prohibited. Quotas, agreements to limit productions or sales volumes, can lead to reduced supply and higher prices, harming consumers. Vertical agreements, while generally less harmful than horizontal agreements, can still lead to anti-competitive effects such as market foreclosure. These agreements occur between companies at different levels of the supply chain, such as between manufacturers and distributors. Exclusive distribution agreements, these can lead to market foreclosure by preventing other distributors from entering the market. Resale price maintenance agreements, where a supplier sets minimum resale price for its products, can restrict price competitions among retailers. The applications of Article 101 TFEU to the maritime sector has evolved significantly. The past regime under Regulations 4056/86, liner shipping conferences were exempted from Article 101, allowing them to set freight rates collectively. This was justified by the need for stability and efficiency in maritime transport sector. The repeal of Regulations 4056/86, it marks a significant shift, exposing the maritime sector to the full applications of Article 101. The European Commission issued guidelines to assist maritime undertakings in self-assessing the compatibility of their agreements with Article 101. The current scenario, since the repeal, agreements between carriers that have the object or effect of preventing, restricting, or distorting competitions are prohibited. This includes shipping pools and other forms of cooperations that involve price fixing or capacity regulations. To qualify for an exemptions under Article 101 Clause 3, agreements must meet 4 conditions. The first is efficiencies. The agreement must contribute to improving the productions or distributions of goods or to promote technical or economic progress. Consumer benefit. Consumers must receive a fair share of resulting benefits. Indispensability. The restrictions imposed by the agreements must be indispensable to achieve this efficiency. And finally, no eliminations of competitions. The agreement must not afford the parties the possibility of eliminating competitions in respect of a substantial part of the products in questions. Technical agreements, such as agreements aimed solely at achieving technical improvements or implementing environmental standards, are generally not covered by Article 101. Information exchange. The exchange of commercially sensitive information can breach Article 101 if it reduces competitions by enabling firms to coordinate their behavior. And shipping pools. It involves the joint operations of vessels by different owners and are considered forms of price fixing if they coordinate capacity and customer sharing. Exclusive supply agreements can lead to market foreclosure if they prevent other suppliers from accessing the market. Long-term contracts, agreements with long-term commitments, can restrict competitions by locking in customers and suppliers. Regulations 4056/86. It was introduced to provide a block exemptions for liner shipping conferences from prohibitions of Article 101 TFEU. These regulations allowed liner conferences to engage in collective rate setting and capacity regulations, which were otherwise considered anti-competitive practices. The primary objectives were to enhance stability, improve service quality and ensure efficient utilizations of shipping capacity. The regulations specifically excluded tram shipping and ancillary services such as travel agency, shipping agency, and shipbroking activities. Liner conferences or the associations of ship owners operating on specific trade routes, coordinating schedules and setting freight rates collectively. Exemptions. The regulations permitted joint price fixing and capacity regulations practices not allowed under other block exemptions. Scope. Apply to international maritime transport services involving the carriage of cargo but not passengers. The block exemptions for liner conferences under the regulations became increasingly controversial over time. Critics argued that these conferences effectively operated as monopolies, restricting competitions and leading to higher prices for consumers. The main points of contention, such as monopoly concerns, opponents claimed that liner conferences could act as monopolies, reducing competitions within the maritime transport sector. Economic impact. The collective rate setting and capacity regulations were seen as impediments to market competitions, potentially leading to inefficiencies and higher costs for shippers and consumers. OECD report. In 2002, the OECD published a report questioning the necessity and effectiveness of the antitrust exemptions provided to liner conferences. The report suggested that the maritime transport sector could achieve efficiency gains through other means, such as individual service contracts and non-price fixing forms of cooperation like consortia and alliances. The European Commission initiated a review process in response to the growing criticisms and the findings of the OECD report. This led to the publications of a white paper in 2004, which assessed the current state of the maritime transport sector and the impact of Regulations 4056. The key developments in the repeal process included white paper 2004, the Commission's white paper highlighted significant changes in maritime transport markets since the adoptions of Regulations 4056. It noted the increased role of independent carriers and the growth of confidential contracting between carriers and shippers. Council Regulations 1419, which was adopted in September 2006, these regulations repeal Regulations 4056 and its block exemptions for liner conferences. It provided a transitional period of 2 years for existing liner conferences to adjust to the new regulatory framework. The transitional period ended in October 2008, marking the full applications of EU competition's rules to the maritime transport sector. From this point onwards, agreements between carriers that restricted competitions were prohibited, void, and unenforceable. Self-assessments maritime undertakings were required to self-assess the compatibility of the agreements with Article 101 TFEU. It ensures that any cooperative arrangements did not restrict competitions. Guidelines. The European Commission issued guidelines to assist maritime undertakings in complying with the new regulatory framework, providing clarity on the applications of Article 101 to maritime transport services. Increased competitions, the removal of the block exemption aim to foster greater competitions within the maritime transport sector, potentially leading to lower prices and improved services for consumers. In 2008, the European Commission issued comprehensive guidelines on the applications of Article 101 TFEU to maritime transport services. These guidelines provide clarity on how competition rules apply to different segments of the maritime transport sector, which includes liner shipping, tram shipping, and cabotage. Defining product and geographic market is a key in maritime sector transport. Product markets include liner shipping, tram shipping, and specialized shipping. Geographic markets are defined by port ranges of trade routes with specific example for liner shipping, tram shipping, and cabotage. Information exchange. The exchange of commercially sensitive and individualized market data can breach Article 101 if it reduces competitions by enabling firms to coordinate their behavior. The guidelines emphasize that the actual or potential effects of information exchange must be assessed on a case-by-case basis. Shipping pools. It involves the joint cooperations of vessels by different owners and are considered forms of price fixing if they coordinate capacity and customer sharing. Without the protections of a block exemption, shipping pools are subject to strict scrutiny under Article 101. Technical agreements aim solely at achieving technical improvements or implementing environmental standards are generally not within the Article 101. These agreements are considered beneficial as they enhance efficiency and service quality. Long-term contracts. Agreements with long-term commitments can restrict competitions by locking in customers and suppliers. These contracts can create barriers to entry for new competitors and reduce market dynamism. Exclusive supply agreements. These agreements can lead to market foreclosure by preventing other suppliers from accessing the market. They restrict competitions by limiting the availability of alternative sources of supply. Article 102 TFEU. It prohibits the abuse of dominant market positions. Key forms of abuse include imposing unfair prices, limiting productions, discriminatory practices, and tying contracts to unrelated obligations. Market dominance is defined by product dimensions and geographic scope. Product dimensions include interchangeable goods based on characteristics and prices. Geographic scope covers regions with similar competitive conditions. Dominant port operators can impose unfair conditions, such as excessive fees. Regulations 4056 address dominance abuses, while Regulations 1419 integrate the maritime industry into the EU competitions framework, enhancing competitions. Three cases highlight the abuse of dominant positions in ports, such as selling Stena disadvantage. Genoa's pilots discriminated against Corsica ferries. Genoa port imposed unfair conditions on Siderurgica Gabrieli. These actions affected competitions and trade. To apply Article 102, it must be shown that the abuse of a dominant positions impacts trade between member states. This impact can be actual or potential and does not need to cover multiple member states, just a substantial part of the common market. Article 107 TFEU prohibits state subsidies that distort competitions unless justified under specific exemptions. It includes a general prohibitions and exemptions for social aid, disaster recovery, economic development, and cultural promotion. State aid in the maritime sector, especially for ports, is controversial. Examples include the French port sector scheme for modernizations and Colmac and Northlink for ferry services, both deemed compatible with EU law. Council Regulations 139/2004, known as the EU Merger Regulations, aims to prevent excessive market concentrations. It defines concentrations, sets turnover thresholds for applicability, and outlines assessment criteria to ensure effective competitions. The EU merger regulations has been applied to various mergers in the maritime sector. Key decisions include CMA, CGM, and Maritime. These decisions focus on competition's concerns and commitments to prevent anti-competitive effects. To comply with EU competition rules, companies must self-assess, seek legal expertise, maintain documentations, train employees, and conduct internal audits. These measures help ensure adherence to Articles 101 and 102 of TFEU. Non-compliance with Articles 101 and 102 TFEU can lead to severe penalties, including fines, cease and desist orders, damages claims, interim measures, leniency programs, and reputational damage. This case of Pronuptia de Paris examined if franchise agreement restrictions distorted competitions under Article 101 TFEU. The European Court of Justice ruled that necessary restrictions for economic system success do not distort competitions and can be justified to maintain franchise uniformity and reputations. The European Court of Justice ruled that Corpo dei Piloti del Porto abused its dominant positions by discriminating against foreign flag vessels like Corsica ferries, violating Article 102 TFEU. Piloting services in Italian ports, including Genoa, were mandatory, but discounts were only available to Italian flag vessels engaged in cabotage. Sealing Stena owned Holyhead Port and operated ferries. It scheduled timetables to disadvantage BNI line. The Commission found this as abuse of dominance under Article 102, applying the Essential Facilities Doctrine. The court noted refusal to grant access or doing so on unfavorable terms is anti-competitive. Merci Conventionalis' exclusive rights to dock services in the port of Genoa led to delays, prompting Siderurgica Gabrieli to sue for abuse of dominance. The European Court of Justice ruled that this monopolistic control and inefficiencies violated Article 102, affecting trade between member states. Stena Sea-Link refused access to its port facilities, disadvantaging sea containers ferry service. The Commission found this to be an abuse of dominance under Essential Facilities Doctrine, hindering competitions on the Britain Island route. United Brands control a large share of the banana market and engage in discriminatory pricing. The European Court of Justice ruled that while holding a dominant position isn't illegal, abusing it through discriminatory practices, however, breaches Article 102. Maersk Line sought to acquire Hamburg Süd, risking anti-competitive effects on 5 trade routes. The Commission cleared the merger with conditions, requiring Hamburg Süd to withdraw from certain consortia to prevent anti-competitive outcomes. In the Irish ferries case, access to the port of Roscoff was denied. The court emphasized the importance of defining geographic market, which affects the assessment of dominance and competitive practices.